What are we to say? Where the rest? What are you doing? So there is nothing much that has transpired. Today the prosecution has decided to withdraw the case. They are saying they have no evidence, and we proved them from day one that they had no evidence to continue with the prosecution. We sought some documents from various police stations, some OBs from Lanet police station and others, Nakuru police station. The prosecutor has said that they do not exist. It tells you that there was no investigation that was done, and so they have made an application to have the case withdrawn. So our contention is they should not withdraw the matter in a manner that will create a future impediment to our clients, in the sense that they may arrest them in the future. So the hopelessness of the case is what has triggered them and caused them to withdraw the case. They will be coming back in the afternoon for a ruling, and that's what the magistrate has directed. We had told them from day one that the case was miserable, that the emperor was naked, and we are being proved that the emperor was naked. So we meet in the afternoon.
But now, you always insisted it was politically motivated. What did you say?
Yes, our fears are not confirmed, but it is their case. Now that they have decided to withdraw it, that shows that there is discipline in the office of the DPP. When they realize their mistake, they are not ashamed to come forward and say this was a mistake, we forget about it and move on. That is the country we want to build, based on integrity, based on truth, based on democracy, based on the rule of law and due process. So let us hope for the best. But the bottom line is that our client was innocent from the beginning. That was a provoked enough issue, and we leave the rest to God. Because you can see even those people who started this process, some of them might not be in office.
It is true.
Yeah, some of them God has removed them. So never fight people. Never fight people without any foundation of fact or law or of being malicious. Tuliomba hapa na tukaomba na unaona Mungu amejibu maombi yetu.
What are your expectations? What are your expectations?
The application is that their case has collapsed and they want to withdraw. And we have said it is their baby. If they want to withdraw, it is their right. Kenya's a democracy allows that process. It's an achievement process for the DPP to withdraw a case. Yes.
Do you think that the judicial systems are working properly?
Yeah, I think our judiciary is working, because you know what? You must have facts and the law must be on your side for you to come and sustain a church's court. That's why you cannot just make false allegations. When you come to court, you must withstand cross-examination and re-examination, so that the veracity of your testimony or the truth of your testimony is tested.
True.
And that's when the court makes an examination. And I believe in our judicial system. Our courts are still working, and we are proud of them. And that is why we want the court to be independent and impartial.
Are there any witnesses you're supposed to prosecute?
Yes, today there was supposed to be 3 witnesses, but it appears that the prosecution will not raise anyone of them. You see, we cannot sustain a case without witnesses. Yeah.
Thank you. Thank you so much. Thank you.
Asante for your support.
Yes.
Kesi imekosa kuendelea kwa sababu washahidi wamekataa kuja. Sasa tunarudi kotini saa 7:30.
Further abuse the process of the court by employing Section 87A of the CPC. Mr. Biko and Ms. Njoki held the view that this was an unnecessary case which is rightfully observed by the prosecution, should be discontinued. They held the view that the case had been instituted to settle quote-unquote political scores. He urged the court to acquit the accused persons under Section 210 of the Criminal Procedure Code and the accused properties in possession of the creator's submission by the defense. Counsel John Maina, on his part, called for unconditional release of the accused person. Mr. Gitari sought for the acquittal of the accused persons under Section 210 of the Criminal Procedure Code. He submitted further that the defense assumption of the accused persons over the same facts hearing, over the fact hearing is speculative. Mr. Maina, prosecutor, on his part submitted that Section 204 of the Criminal Procedure Code is not applicable. He stated that Section 87A is the applicable section and asked the court to allow the application as prayer. This is the court's considered view. I have been referred to several legal provisions. I deem it fit to reproduce the same at the beginning. This is Section 87A of the CPC. Court. In a trial before a subordinate court, a public prosecutor may, with consent, judgment is pronounced, withdraw from prosecution of any person, and upon withdrawal under Section 87F, if it is made before the accused is called upon to make its defense, it shall be discharged, but the discharge of an accused person shall not operate as a bar to subsequent proceedings against him on account of the same fact. Section 210 of the Criminal Procedure Code. Quote, if at the close of the evidence in support of the charge, and after hearing such sum up submissions or argument as the prosecutor and the accused person or his advocate may wish to put forward, it appears to the court that the case is not made out against the accused person sufficiently requiring to make a defense, the court shall dismiss the case and shall forthwith acquit him. End of quote. Section 204 of the Criminal Procedure Code provides, quote, if a complaint at any time before a final order is passed in a case, under this part, satisfies the court that there are sufficient grounds for permitting him to withdraw his complaint, the court may permit him to withdraw it and shall thereupon acquit the accused person. End of quote. The sixth schedule on transition and this is the sixth schedule of the Constitution on transition. What? All law in force immediately before the effective date continues in force and shall be construed with the alteration, adaptation, qualification, and exceptions necessary to bring it into conformity with this Constitution. The application and the responses revolve around the above provisions. For clarity and as a way of distinction, the last amendment of the present Section 87A was in 2012. This was way after the effective date of the Constitution. Hence, any alteration, if intended, would have been introduced at the subsequent amendment. Testing Section 210 under the present position, it is instructive and unequivocal that Section 210 of the Criminal Procedure Code only relates to circumstances after the close of the prosecution's case, which is not the case herein. Section 204, on the other hand, relates to withdrawal of complaint by the complainant. As is the practice, such withdrawal is only made on oath, which is not the case here. What then is the recourse under the circumstance? As pointed out, the provisions the prosecution sought to employ withdrawal of the case herein under Section 87A of the Criminal Procedure Code. The end result is not in contest, that its result, if allowed, to a discharge and does not bar subsequent charge of the accused person on account of the same facts. This is not a termination of a case per se. The case would remain alive and at the will or discretion of reinstitution by the prosecution. The case shall remain hanging on the neck of the accused person. The accused person shall live in perpetual fear of rearrest and reinstitution of the charges on similar facts. In deciding whether or not to allow the application, the central principle to be borne in mind is whether the threshold have been met. In exercising discretion under Section 87A of the CPC, the court must satisfy itself that the threshold for grant of such order is demonstrated. In this case, the prosecution has outlined 4 grounds as espoused above. The ground revolves on insufficiency of evidence to sustain the charge. As it stands, according to the prosecution, the charges as they are bare and unsupported. In the absence of the evidence, they find difficulty in procuring. 9 witnesses have testified as listed in 4. It is upon reviewing the evidence recorded so far that the prosecution deemed it necessary to discontinue the prosecution of the accused for insufficiency of evidence under Section 87 of the CPC. The defense on their part, as much as they do not object to the termination of the charges, or the view that to bring closure to the matter, then acquittal would suffice. This charge, according to the defense, is prone to misuse, an act that would infringe to the accused person's right guaranteed under Article 50. I agree with the defense that discontinuance of the matter under Section 87A of the CPC would not bring closure to the matter, as it shall remain an active sword that can be swayed by the prosecution and their will. The prosecution, on their part, maintain that it is not in possession of sufficient evidence capable of sustaining the charge, and deem it proper to discontinue the same at this stage under Section 87A of the Criminal Procedure Code. The prosecution cites its inability to avail crucial witnesses to prove the charge, and as it stands, the charges against the accused person are not supported. The prosecution is silent on its potency to reinstitute the charges should the application be allowed. Taking a cue from Mr. Biko's submissions on proper utilization of the court's time, of what use would be to the court to sustain a charge admittedly not supported? What would be the party's cost implication of attending to a trial whose evidentiary content is known and admitted in the prosecution? It is a non-trial, in my view, and sustainable trial, and sustaining the same would be by extension entertaining the abuse of the process of the court. In as much as I sympathize with the accused persons who have been subjected to this admittedly unnecessary trial for over 18 months, the only available recourse would be to allow termination of the case under Section 87A of the Criminal Procedure Code. This court's ruling is explicit as to the admission by the prosecution of its ground for the termination of the case, that is, the account of lack of evidence. Admission that the prosecution does not possess sufficient evidence to sustain the charge, to sustain any of the charge against any of the accused persons. In the end, I allow the prosecution's application to withdraw the charge under Section 7A of the CPC. Each accused person is discharged accordingly, and I direct that the cash paid deposited by each of the accused persons in court be refunded to the respective depositors. Those are the orders of this court.
Most obliged.
Well, Your Honor, we highly appreciate the ruling of the court. I don't think on my behalf and behalf of my clients, and perhaps my wish to thank the court for the time it has taken, the resources that were spent towards this well, and the patience within which the court has attended to all the parties. We highly appreciate, and should there be a recommendation to a higher bench, be assured that I shall be one of the referees.
Amen.
And as such, Your Honor, and on behalf of my clients once more, allow me to wish the court a Happy New Year, a Merry Christmas, and Happy New Year.
Your Honor, I made a request for the phones before you turn off. I need those phones. Mr. Oye has no business with them anymore. And the shortest time possible, if possible, close of business today. Unless they are elsewhere, those phones should have been here. There are also exhibits on the floor. Those exhibits also be released accordingly. There are poles, those are farm tools, the equipments. We do request that they be returned to our clients. All the things that were called paraphernalia be released to them. This court has since handed down its pronouncement in the matter, and we thank you so much. Absolutely so. Thank you.
Yeah, it's pretty boring. We are very thankful for the offered us with this.